So I'll introduce our president. But before I do that, just so you know, this event is hosted by the LA City College Book Program. Every year we choose books or a theme that we think matters. And this year our theme is Immigrant Stories, How We Came Here. And so our focus this fall has been on a Mexican-American writer. And I hope you were fortunate enough to have been at her October 29th presentation where she described her book in life. And today we have a lawyer, who is here to talk about the legislation surrounding immigration issues. Excuse me. In the spring, we're hoping to bring an Armenian-American author and an African-American author, and in the coming fall, we'll focus on the Middle East. And so we have really interesting writers coming. I'm so glad you came, talk it up, and now we'll begin. It is my great honor. Oh, by the way, I just forgot two things. One is, if you are faculty, make sure you sign in for your reflective credits. And if you have a question for Thomas A. Saenz afterwards, just make sure it's a question and it's to the point. So, without further ado, I'll just say I'm Alexandra Meck, and it is my great pleasure to support one of our best supporters, our president, Renee Martinez.
Wow. Well, today is really an honor because I have been to a few of the Malta award events and have had the pleasure of seeing many local people get those awards, which is really gratifying. But Thomas Saenz is famous, and in regards to, currently he's president and general counsel. I think he had a really exciting time when he was working with the former mayor, Villaraigosa, many of the challenges that occurred during that time, especially in terms of governance of the LA Unified School District. But I think the most important thing is that he was born and raised in Southern California. He's one of our own. As a matter of fact, we lived in a similar city, Alhambra, at a time. Proudly, he graduated summa cum laude. Did you hear that? Summa cum laude from Yale University, and he received his law degree from Yale Law School. He also served as a law clerk for many prestigious judges, Honorable Hump and Honorable Brinhart. But I think that the proudest that I am is, and I actually have the magazine, the Hispanic Business Magazine. In 2009, I was looking for it this weekend, where it states that he was or is one of the 100 influential Hispanics in California and throughout the United States. His work has been unbelievable, especially for the anti-immigration Proposition 187. He's really been involved unbelievably on civil rights issues, and it continues. And I know this has an impact on many of you. I too have family and friends whose children were born here, but they were not. And the struggles that they have. I just had an experience where one of my friend's mother died. She could not go to the funeral because she did not have papers to cross the border. So that there are many things that are still going on now that really have an impact on everyday life and on lives of students that family who immigrate to our country. So with honor, I want to present Thomas Saenz, our current Malta president, and I think he'll share with you his exciting life that doesn't end. But as you want to learn about things that you could do and what you would want to support, I think he's here to give you some guidance and some strategies. Thank you.
Good afternoon, everyone. I want to begin by thanking all of you for being here, and I want to thank President Martinez and the College and the College Book Program for adopting this topic, immigrant stories, this year. It is an extremely timely and important one, although one could probably say that about the issue of immigration for at least the last 10 years, and perhaps every year or every other year in the last century. That's how important the issue of immigration is to this country. I'm proud to be here as a Los Angeles native. I'm proud to be here as a longtime civil rights lawyer who works with lots of the leaders nationwide who are involved daily in trying to lead our nation to a better set of immigration policies than the ones that we have. And we'll talk a bit about what I think some of the flaws in our existing system are, and what are the prospects for changing that. But it's also an important time to have this topic because 2015 happens to be the anniversary of a number of important developments in the area of immigration law. But before we get to those anniversaries, I'm going to go back even further. So you've probably heard accurately the United States described as a nation of immigrants. It's almost a cliche. In fact, even some of those who describe us as a nation of immigrants, in the very next breath, will talk about undermining the fact that we're a nation of immigrants by advocating policies that are inconsistent with our history, inconsistent with our Constitution, and inconsistent with what a nation of immigrants needs to preserve in order to thrive going forward. But I want to go even further and argue that not only are we a nation of immigrants, we are a nation in part because of the immigration issue. So in fact, the Declaration of Independence, I know it's a much longer document than we all recall when it was presented to us in class, but as you know, it includes a number of grievances by the colonists against King George. But one of the grievances in the Declaration of Independence is a concern that King George was not promoting immigration to the colonies. And in fact, that he was putting in place laws to obstruct immigration to the colonies. So from our very first Declaration of Independence, immigration had been a central issue with regard to the United States and its government. Now fast forward a bit to the Constitution, you all recall that we went through a number of years under the failed Articles of Confederation, a loose union of the different colonies at the time, and opted through a constitutional convention and then ratification of that constitution to have a central government, a true uniting of all of the states as a single nation. Now the reason I emphasize that is the most important principle, often forgotten by folks running for president, by folks who are governors of states, by folks who are legislators. But the main principle with respect to immigration is to remember that immigration must be a federal policy. Now that's not just because the Constitution says so, and it does, because the Constitution says that Congress will establish rules for naturalization, rules for those who are immigrants, not born here, becoming citizens. And it says that Congress and the federal government, through the president, will oversee foreign policy, our relations with other countries. And there are a few issues that have more of an impact on our relations with other countries than immigration. So because of that, the United States Supreme Court has long determined that we can only have one immigration policy in this country. Important to remember that. It's also logical, because if we allowed each of the states to have their own immigration policy, we would no longer be a nation. Because if Arizona had its own immigration policy, and in this day and age, we know that would differ from California's immigration policy, and that would differ from New York's immigration policy, and that would differ from North Carolina, the most recent to enact an anti-immigrant state law, immigration policy. And if each of the states had their own immigration policy, we would not be one country. We would be 50 different countries, each determining who gets to come in, who's barred, who's removed, on their own. So immigration and a central immigration policy is not only a part of our historically becoming an independent nation, it is part of what makes us a single nation rather than 50 different countries with their own immigration policies. Logical, it's in the Constitution, even the Supreme Court agrees that in this country we can have only one immigration policy, and it is set at the federal level. So no matter how much Arizona, more recently, California, 21 years ago, with Proposition 187, or any other state may disagree with the federal immigration policy, none of those states have the right to decide on their own immigration policy. We have one uniform law on immigration in this country, and we must in order to remain a nation. Bedrock principle number one. Now, unfortunately, our federal government, which has that responsibility, singular responsibility for immigration policy, has historically not done a particularly good job at arriving at a workable immigration policy. Okay? For a number of reasons. But now let's talk about some of those aberrations. So October, just a month ago, was the 50th anniversary of the Immigration Act of 1965, signed by President Johnson on October 3rd, at the foot of the Statue of Liberty, was cited by Johnson and others as a civil rights achievement, going along with the Voting Rights Act, enacted a few months earlier, and also in 1965. Going along with the Civil Rights Act of 1964, a year earlier, protecting against employment discrimination and discrimination in public accommodations and discrimination in government programs. And the Fair Housing Act a few years later. So the Immigration Act of 1965 was identified then and viewed as a part of a package of civil rights laws, all enacted in the mid-1960s. And the 50th anniversary was among them. Now, why was the Immigration Act of 1965 identified as a civil rights achievement? It is because it, for the first time, abandoned the national origin quotas established in the 1920s and reaffirmed over President Truman's veto in 1952. But these were quotas for immigration that were self-consciously and blatantly defined to favor immigration from Northern and Western Europe over the rest of Europe, and immigrants from Europe over and above immigrants from everywhere else in the world. Okay. These were quotas that consciously sought to increase immigration from Northern and Western Europe to the detriment of the rest of the world. So the 1965 Act is the first time, think about this, only 50 years ago, that the United States abandoned a formally, facially, racially discriminatory policy that favored Northern and Western European immigrants over others from throughout the world. Not that long ago. But that's why it was viewed as a civil rights achievement. However, the 1965 Act did two other important things. First, it established a uniform quota, the same quota, the same ceiling on annual immigration for every country in the Eastern Hemisphere. So it didn't matter how big that country was, didn't matter what the demand to immigrate might be, didn't matter whatever historical connection there might exist between the United States and specific nations. Every nation in the Eastern Hemisphere in 1965 got the exact same ceiling quota on annual immigration to this country. Second thing that the 65 Act did is, for the first time, the United States began to control, formally, immigration from Latin America, from the Western Hemisphere. Now that's important, because you may hear people, as they debate the issue of immigration, say, well, my grandparents, my great-grandparents immigrated legally. Okay? The truth is, we didn't have the same immigration system prior to 1965. So anybody who's talking about an immigrant prior to 1965, don't listen to them argue that their grandparents, great-grandparents immigrated legally. It was an entirely different system. And in particular, for immigration from Mexico and the rest of Latin America, the system prior to 1965 was largely informal. For better or worse, and I'll explain to you both. it meant that our border was not really controlled. Yeah, there would be inspections in certain areas, but there was no attempt to decide if a person had the right to enter or not, particularly prior to 1965. However, the bad side of that was that there was also informal removals of massive numbers of people when the country or regions or states decided, usually because of economic conditions, to scapegoat immigrants, usually from Mexico, and kick them out en masse. But because entry was so informal, then the removals were informal. And there were massive deportation or repatriation campaigns in the Great Depression and in the 1950s in something called Operation Wetback, an offensive name. I'm only naming it because one of our presidential candidates apparently has decided in his infinite lack of wisdom that that somehow is a model for what we should return to. But what it was an informal, though extremely well-resourced by the government and undertaken by the government, to remove huge numbers of Mexican Americans. Note, I don't say Mexican immigrants, because these were informal campaigns, and as often as not, United States citizens born in this country were kicked out, removed, taken by train or bus across the border, along with those who were immigrants. Again, largely because of the informal process of controlling Latin American immigration. It all changed in 1965. Now, 11 years later, in 1976, and think about that, that's less than 40 years ago, another change was put into place that dramatically affected immigration and continues to affect immigration today. And that was an act that then took those national origin quotas, equal for every country in the Eastern Hemisphere, and applied those quotas to countries in the Western Hemisphere. So it meant, once again, that every country, no matter how close they were to the United States, no matter how much of a historical connection, no matter what the demand was to immigrate to this country, has the same annual ceiling quota on immigration to this country. Now that remains in place today. It does not mean that in numbers at the end of the year, there is the same number from every country, because there are certain categories of immigrants who are excluded from that quota. But it does mean that even today, any one of you could go to the Department of State website and subscribe to a monthly visa bulletin. And what that visa bulletin will tell you is what is the wait for various categories of potential immigrants to obtain a lawful visa to enter this country. In 1965 and following, as it's been amended as recently as 1990, our immigration system basically has categories of potential immigrants. Those categories are defined by the potential immigrant's relationship, family relationship to someone who is in the United States, either as a citizen or lawful permanent resident. Or in other cases, the categories relate to the skills, job skills, professional skills that potential immigrant brings. But that visa bulletin that any one of you could subscribe to and gets emailed to you on a monthly basis tells you for each of those categories of immigration what is the wait from having your application completely filled out, approved, for a visa to come on. And if you were to subscribe to that bulletin, what you would see is that for most nations in the world, the wait is 4 years or less. Differs based on category, but about 4 years or less. However, for a handful of countries, the wait is longer, depending on the category. And in particular for potential immigrants from Mexico, where the demand is highest to immigrate to this country, the wait can be 10 years and more longer than for the exact same kind of potential immigrant, same category, from any other country in the world. So I ask you to think about that. 2 reasons. Next time you hear a political leader, and even our president is guilty of this, say that they should get in line like everyone else, you need to say back to that leader, even if on television you should say it, to remember, there is no one line. There are different lines. And which line you are in depends both on what category of immigration, family relationship, professional skill, and the country you come from. And that for Mexico, the largest source of undocumented immigration in this country today, those lines are much, much longer. And as you talk to that leader on the television, you should ask them, if you knew that your line was 10 years longer than someone else's, with the same relationship to someone in this country. In other words, if you had to wait 10 years longer to reunite with family members than someone else, would you wait? Or would you find a way to circumvent that unfair system to be with your family? This is what none of our leaders will acknowledge publicly or describe. So much so that when I raised this issue at a California State Bar convention, full of lawyers, I got a lawyer in the audience who heckled me and said I was wrong. I'm not, by the way. Again, you can get the bulletin yourself. State Department website, you can subscribe. But that's the level of lack of knowledge of our immigration system. That we allow our political leaders, from the president on down, to talk about one line and people who circumvent the line, when that's not our system. Our system is one that includes unfairness. Go back to what I started with. We can have one and only one federal immigration policy in this country. But the constitutional corollary of that is that we allow the federal government, in setting immigration policy, to violate constitutional principles that we would not allow them or any other government official to violate in other circumstances. Because can you imagine if we had colleges or universities that had admission systems that said, if you come from this country, you have to wait 10 years to be admitted to our college or university. But if you come from another country, we'll admit you in 2 years. Now, I hope you all know that that would immediately be challenged in court and struck down, because it violates the 14th Amendment's guarantee of equal protection of the laws. Government may not discriminate on the basis of race or national origin unless it can justify that discrimination with the strongest and most compelling of reasons, and it tells immigrants from Mexico and a handful of other countries, but Mexico the worst, that you must wait longer than a potential immigrant from any other country. We allow that because the federal government's plenary, which means complete power over immigration, permits them to engage in that kind of discrimination that would not be allowed or tolerated, including by some of the very same politicians who will screen their support for this immigration system and decry the undocumented. But in the same debate or the same policy statement, will argue that they are in favor of colorblind admissions to universities and colleges. Great contradiction, permitted by our Constitution. So, when we talk about the need for immigration reform, we focus generally as a nation on our undocumented population. And indeed, the greatest imperative in my mind and that of most in support of progressive immigration reform, the greatest imperative is to provide legal protections to those who have been here, contributing to our economy, raising families, supporting our society, without the benefit having a lawful permanent resident visa. But that's only one element of what we need to do under the rubric of immigration reform. I would argue that we need to have in place an immigration system that whatever the Supreme Court and Constitution would permit, we can and should adopt immigration policies that are more consistent with our principles in our Constitution and in our governments. That begins with eliminating the discriminatory system that makes immigrants from certain countries wait longer than similarly situated immigrants from other countries. This is often called future flow, an important element of immigration reform. First element is providing legal protections to the undocumented currently present. Second element is fixing future flow, so we no longer have this discriminatory system with long lines based in part on facial discrimination in the law. We also need to adopt practices in our immigration courts that better reflect principles of due process. Many of you have probably had experiences, either your own or your family members, with immigration court. And if you do, you know that this is nothing like any other court in this country. Oftentimes, there's inadequate interpretation or no interpretation. No one is entitled to a lawyer other than the government. If you can afford one or can obtain one for free, you have one. But we don't provide lawyers in immigration court, even though the consequences of that court's decisions are often more severe than what would happen in a state court with a criminal or civil proceeding. We don't provide all of the due process in our immigration adjudication system that we do in our state and federal court system. Third critical element of immigration. Fourth element is that we have to ensure that our principles are also reflected in how we treat those who are detained for immigration reasons. As you all are probably aware, there is a movement across this country to eliminate family detention. Not yet agreed to by the administration, which continues to operate horrific detention facilities housing women and children in prison, not for a criminal violation, but because of an immigration violation or alleged immigration violation. We would not permit that, at least in the last 50 to 100 years, in any other context. But there are similarly deplorable conditions for single male and female detainees who are often kept without a set date for when they will get out, without knowing what process is required for them to get out. And that too would not be tolerated in any criminal detention system in any state across the country. Fifth important principle is that we must make clear that there will be one and only one immigration policy in this country. And this relates to what you are all familiar with. This phenomenon of states and localities seeking to enact their own immigration control regulations. We saw it beginning 5 years ago in Arizona, and there were 5 states, I call them together, the dirty half dozen, that followed Arizona and enacted their own, in some cases worse, in some cases slightly better, versions of Arizona Senate Bill 1070, which sought to regulate immigration through racial profiling, through economic services in the state of Arizona. But another important anniversary, and one that I hope gives some reason for optimism. This past Sunday was the 21st anniversary of when this state, California, enacted Proposition 187. Now, it makes me feel old when I talk to college audiences about this, because by and large, many of you in the room who were very, very young, if you were even alive 21 years ago. But Proposition 187 was an important part of my career as a civil rights lawyer. We, along with others at MALDEF and other organizations, successfully challenged that law. But to remind those of you who learned about it as history, or who experienced it but was so long ago, Prop 187 was the clearest precursor of Arizona's law. In many ways, it was worse. It required every public servant, including teachers, including community colleges, including hospitals, including social workers, including law enforcement, with every person they interacted with, to decide if they had a reasonable suspicion that that person was undocumented. And if they did, they were supposed to deny services, meaning not allow that suspected individual to enroll in school, or to receive a doctor's care, or to receive a social worker services. Second, they were to tell that person by a formal notice that the state of California believes you to be undocumented and that you should leave or change your status, as if it were that easy to change your status. Third, every one of those service providers was to report that suspected individual to the state attorney general, various other state officials depending on the service, and to the then INS, the precursor of ICE. That's what California enacted by 58% of the vote 21 years ago last summer. Now, it was struck down in court, as I mentioned, through the efforts of MALDF and a number of other civil rights organizations. Other than two very minor provisions, it was struck down and was never implemented in the state. It took years to finally get it struck down in court, but it was never implemented in the state. The reason for optimism is that California, 21 years later, a generation later, fairly quick in political terms, is a dramatically different place than it was 21 years ago. 21 years ago, we were Arizona today. We were the state trying to lead in punishing immigrants the most. Today, 21 years later, this state is one of the most, if not the most, welcoming of immigrants in the country. That includes some unprecedented, precedent-setting, because they have been enacted in other states as well, pieces of legislation to actually provide benefits and support in limited circumstances to those who are undocumented. And that change didn't just happen because 21 years went by. It happened because there was a reaction to those who put Proposition 187 on the ballot, in particular Governor Pete Wilson, who used it as a mechanism to secure his re-election as governor. Same way, in Arizona, Governor Brewer used SB 1070 to secure her re-election. I always used to say, prior to her being re-elected, that she was following a Pete Wilson playbook, but she must have gotten a version that was torn in half, and she didn't read the rest of the story. Because yes, Pete Wilson got re-elected governor, but his political career was over. I think he ran for president, his campaign lasted like a minute and a half. Okay? And since then, he's never been heard from. He's a bad word in politics in this state. When Meg Whitman made him chairman of her election committee, she suffered for it. His political career was over, much like Jan Brewer's is now, thank goodness. But she didn't learn the political lesson of 187. It catalyzed change in this state, largely because people who had the right to become citizens, who had the right to register to vote, who had the right to vote, but had not been doing so, were inspired by the threat of 187 to do those various things. Increases in naturalization, in voter registration, and voter participation that has changed the political complexion of California permanently to reverse from being the leader in anti-immigrant lawmaking to the leader in immigrant integration today. That's a reason for hope and optimism in what I do. Now, back to immigration reform as I conclude. Now, regrettably, the issue of immigration reform has become unduly politicized. You see it in presidential campaign debates. You see it in the statements that are made by leaders of the House and the Senate. You see it as the issue plays out in the media day by day. Previously, immigration was viewed as a bipartisan issue where leaders from both parties would come together and compromise and arrive at immigration legislation that would then be